Welcome to the dialogue entitled Bokhary-Peerenboom Dialogue, Rule of Law in Hong Kong and Mainland. I am Clara Leung, a student from Morningside College, and I will be your Master of Ceremony tonight. May I first invite our College Master, Professor Sir James Verlies, to give an opening remark. Professor, please.
Thank you for coming. Thank you particularly to the competence, the speakers who are going to be talking about the rule of law. Let me tell you a little about Professor Peerenboom, who is a distinguished visitor to the college, Morningside College, for this week. When I was reading his background, it occurred to me that I enjoyed the title, as you may know, of a distinguished professor at large. And now I thought that Professor Peerenboom was truly a good example of a professor at large. He's a professor of La Trobe University, an associate fellow of the Oxford University Centre for Socio-Legal Studies. He was at UCLA Law School only a few years ago, but he lives in Beijing and does a lot of expert witness stuff in courts there, as well as pursuing his academic business. He has a fine long list of books, but I think I oughtn't to take the time now to tell you about that. Justice Colonel Bokhary was one of the three permanent judges of the Hong Kong Court of Final Appeal. Until fairly recently, he is still on that court, though not a permanent member. I am told that in his tenure, which was over 13 years, he heard 95% of the cases that came before the court, which is a pretty high rate. I suspect the rate is still fairly high. He is also said to have been the Liberal member of the court, and he is famous for dissenting judgments of compelling logic. So these are our two discussants tonight. And the moderator for the discussion is Dean Christopher Gane from the Law Faculty, who has been here since September 2011, and before that had the excellent position of Chair of Scots Law at the University of Aberdeen. But he was also Dean of the, effectively, of the faculty there. I should, I believe, call you all to the platform and let matters begin. I think we will have the... Thank you very much.
Can I ask, first of all, whether you can hear me without the microphone? Yeah? Do I need to use the microphone? I do. Well, here we go then. I promise I won't start singing. Sir James, distinguished guests, colleagues, members of the college, ladies and gentlemen. Sir James has very ably introduced our two discussants this evening, so I won't go through the biographies of either of them. I will, however, just add a couple of comments about our two speakers, because I think it's particularly apt that they are here to discuss issues of the rule of law both in China more generally, but also, of course, in the context of Hong Kong. And that's first of all in the case of Professor Peerenboom, because his writing in relation to the rule of law is not, of course, just focused on China. He's written on the rule of law as a concept in many other areas. But one of the important characteristics of his writing, I think, is that it provides a lucid and very carefully researched and argued set of challenges on the rule of law. Challenges to China itself, of course, but also to those, especially, of course, I think those in the West who've tended to espouse a view that the only rule of law for China is a form of that doctrine that would be accepted in established Western democracies. And I think that's a very important position that I'm sure we'll get the opportunity to explore more fully here. I think that Mr. Justice Bokhary is well known to many people in this audience, but I think the very important thing here is, leaving aside the general distinction of his judicial career, is the fact that he was involved, of course, in virtually all of what might be described as the formative case law of the Court of Final Appeal in its early years and on from then, which brought Hong Kong to address very squarely the rule of law. And so we have two quite different perceptions, or potentially different perceptions, from an academic view and also from someone who has, if you like, hands-on experience of the practical implications of the rule of law. Can I just explain how we would like things to proceed this evening? And this is with the agreement of our two discussants. This is intended to be a dialogue between our two speakers. And to that end, we asked them to give us a few pointers towards the things that they would like to talk about in the evening. And we'll turn to those in a moment or two. And these include general questions like what is the major challenge to the rule of law in China, important questions about whether or not a partially formed democracy like Hong Kong is capable of sustaining the rule of law, and other important issues related to that, for example, such as the question of the rule of law in a one-party state and the future of the rule of law in a one-party state. So we'll turn to those questions in due course. But in the meantime, we'll kick off with a very general suggestion to both our speakers to maybe just explain in a few words their conception of the rule of law. Maybe we'll find then that there's so much consensus that we can go straight to dinner after that, or that there are the roots of a genuine discussion going to emerge here. Again, both speakers are very happy will involve the audience later on in the discussion, but there may be appropriate points during the discussion to throw things out to you, so both speakers, again, are happy to go forward in that way. So I maybe turn, first of all, to Professor Peerenboom and to introduce the concept of the rule of law and his perceptions of it.
Well, thank you, first of all, very much for having me here. It's a great pleasure always to come to Hong Kong and in this case, come to Morningside College. Very much like this setup as well of having a dialogue with distinguished justice to talk about the issues in Hong Kong and then to compare what's happening in mainland China and also to think about the relationship between what happens in China to Hong Kong. So to answer this question, I don't think we're going to come to great agreement about rule of law, and I would say that our purpose shouldn't be to come to an agreement about rule of law. Rule of law is a contested concept, a notoriously contested concept. The very fact that you can have people championing rule of law in the U.S., for example, from a liberal perspective and a Republican perspective and a progressive perspective, should give you a hint that they're talking about something slightly different or mean something different. But if you think about the fact that it has also been used to talk about ancient legal systems, to be used in Singapore, to be used in China, clearly the leaders of China have a different notion of what rule of law is than, say, many people would have in a liberal democracy. So for me, it's what I try to do is always say, let's just be clear about whatever definition it is we're using for rule of law, and try to have that definition fit purpose. So if you're doing empirical work, you may have a different definition. So for me, it comes down to something quite simple, and that is that you need to have meaningful restraints, legal restraints on power, on political power. And if you don't, you can have laws but that are used purely instrumentally, but if they don't put some check on power, and if people are not at least normatively obligated to follow those laws, you're essentially dealing with a rule by man type of system and not rule of law. So there's much more that can be said about it, and what I've done in the past is to distinguish, and following many other people, distinguish between thin rule of law and thick rule of law, or procedural rule of law and substantive rule of law. And we generally have a sense of what the thin rule of law is. The rules need to be prospective, they need to be consistent, they need to be followed, and so on. Those apply to every legal system. But then there's a set of broader issues about the role of the courts, how much power the courts have, separation of powers, and how all of the judiciary is related to the political system, to human rights, to the economic system in which it's embedded. And that then gets into these thick conceptions of rule of law, which are differ from country to country, and are contested, obviously, even within a country. So let me stop there.
Well, I'm very grateful to you for giving me this opportunity to sit at Professor Peerenboom's feet and learn of his wisdom. It might have been better if you had made this opportunity available to me quite a number of years ago when I was a full-time member of the court. But I'll make what use I can of it, even though I only go back there from time to time. Now, I am very sympathetic to the idea that the rule of law has, in many ways, different meanings, and legitimately has different meanings in different places. But of course, insofar as any power in the East rejects the conception of the rule of law as evolved essentially in the West, you would have to ask yourself whether that rejection is based on something within the wishes of the people, or only for the convenience of those who rule, and do not find the rule of law particularly convenient for their purposes. Now, my ideas of the rule of law have very much to do with human rights. It is part and parcel of what I think people in Hong Kong hold dear when they talk about the law. And if this conception is wrongly described as the rule of law, I'm quite happy to abandon the term for something better. The people of Hong Kong know what they're talking about, and they know what they want. Now, the rule of law is a term which can be respectably said to have practically no meaning. Lord Bingham said that as far as Britain is concerned, that contention was rendered impossible by, apart from anything else, the fact that the expression is used in an English statute, which deprives any English lawyer of any opportunity, assuming that she or he wanted one, to deny that there is such a concept. I have tackled the question in my own mind, with others abroad and with others in Hong Kong, whether the rule of law can be maintained in the absence of fully evolved democracy. And I have given an answer of a conditional type, and the answer is yes on certain conditions. Those conditions do not define the rule of law, I would not know how to define the rule of law, but I think they give some idea of its essence. I don't want to go into those conditions now because we might be discussing it in connection with that specific question of whether it is possible to maintain the rule of law in the absence of fully evolved democracy. My conditional answer, yes, was disputed by my very dear friend, Mr. Martin Lee, privately. Publicly, he hasn't disputed it, but he told me that he thought it would have been too negative for me to say no, and he agreed that I was right to say yes, even though he thought I was wrong to say yes. Such are the difficulties about the rule of law. Thank you very much for the moment.
Would you like to respond to that question that's just been thrown out about the rejection of a Western model of the rule of law in any given community that doesn't consider itself to be part of that family of Western rule of law believers?
So if we go back to this notion of a procedural rule of law or a thin rule of law, that is something that for which it's not contested and is generally accepted, for example, in China, could be accepted in a theocratic state. For a legal system to have that kind of regularity, to have consistency, these are things that are basic elements, the formal elements of a legal system. If you cannot comply with that, you don't really have a functional legal system. These things are actually very difficult to achieve. They require, legal professionals, institutions. They require wealth to train up people and to run these institutions. So many developing countries have problems achieving them. So when you talk about countries rejecting rule of law, they're not necessarily rejecting that aspect of rule of law, and that's why you can have technical assistance programs by the ADB or the World Bank that Vietnam and Venezuela and China can all accept, because they say, fine, this is consistent with our goals of what that we want the legal system to do and how we think the legal system should function. But beyond that, what they reject is the notion, for example, of the relationship between rule of law and human rights, rule of law and democracy, or particular conceptions of what the legal system is supposed to be doing. And in that sense, again, I don't think it's a question of which one's right or which one's wrong. These are concepts, these are ideas. I'm not making a normative argument about a conception of rule of law that a socialist conception of rule of law is the correct one and a liberal democratic one is the wrong one. It's simply to say that these are different big conceptions, and you can argue about them normatively, but you just need to be clear about the distinction, the nature of the distinction. So what's happening in China, and of course they also have different uses. So if you want to do an empirical project that examines the relationship of rule of law to economic development, protection of human rights, the promotion of democracy, you cannot incorporate those things within the conception of rule of law, because then you don't have anything to test. So generally, the relationship of people who use these things, who try to use them, social scientists tend to prefer these thinner definitions of rule of law. So in that sense, I think when China, for example, says they reject Western conceptions of rule of law, what they're talking about is obviously rejecting democracy, thinking of a different role for the party, for political parties, and having the legal system and the leadership role of the party being something very different than you would see within a liberal democracy. And it may come down to more concrete issues. For example, what is the role of the court? How much power should the courts have over what range of issues should the courts be allowed to decide? What issues should be left to political organizations, such as the party? And that may differ from, say, a liberal democracy to a single-party state.
Thank you. There's quite a lot in that answer. Are there any particular point that you would like to follow up on?
Well, I keep coming back to the question of democracy, because a state ultimately can only speak through its organs of power, essentially its organs of executive power. If that power is formed by a democratic process, then to that extent at least, it is, as a government of the people and by the people, speaking for the country in some realistic way. Their choice, whatever that may be, should be respected within their borders and across international boundaries. In the absence of democracy, it is impossible to know. In fact, the opposite is easier to discern more often than not, that what the state is choosing is not the country's choice. Now, the Western conception of rule of law was, taking Professor Dicey as the chief proponent of it, until recent times, essentially procedural. It involved a lot of faith in the essential climate of legality within the country, in that case Britain, and maybe the faith wasn't badly misplaced. Indeed, was quite recently that Lord Hoffman said that in the absence of Marbury and Madison-style judicial review, which we call constitutional review, these things have been left in the hands of Parliament, and that seldom has the British Parliament let the British people down. But again, that illustrates that any acceptance of a thin conception of the rule of law becomes particularly thin to the point of non-existence, in my view, in the absence of democracy.
One very quick point about that. That I agree that there are no real life examples of a single party authoritarian state that has fully implemented even a thin version of rule of law. So let's give an example of a country that ranks very high on rule of law indices, and yet is not a democracy, or was not a democracy at a period of time. You can think of two offhand. One is Singapore, of course, where you could, however you want to describe the legal system, there are certainly things where it was not the kind of democracy that most people think. In any event, it still scores very highly in terms of the legal system on most indices, which are, again, these thin rule of law indices. The other example of a country, now a jurisdiction, that scores very highly on these and was not a democracy is Hong Kong. Hong Kong now, and Hong Kong previously, was not a democracy, and yet had what most people consider to be a fairly robust version of rule of law. So it's possible in some sort of circumstances, but in general, without democracy, you see too much abuse of the legal system for political ends, and you see cases in Singapore where that is certainly true when you have defamation cases against opposition parties and so on, where these are the limits of the legal system. And my prediction would be, if you were going forward in China, you would see the same thing. There are many improvements, and the legal system could function much better and would function perfectly fine in many areas, and yet there would always be an area where political power would trump legality and the rule of law under those sorts of conditions.
Well, that's absolutely right. Now, the people of Hong Kong with whom I grew up have now got a different mindset from the one that they had in years gone by, still within collective memory. There was a time when the people of Hong Kong expected very little of government. They tolerated conditions which, to be quite frankly, were well nigh intolerable. They lived in the expectations of what would dawn for their children. Some of those children have seen that the dawn has not come. We have now got a truly justiciable constitution in which people can go to the courts for their rights, and they will go there with increasing insistence and increasing dissatisfaction if the courts do not deliver. The other avenue by which they will pursue their rights, if not through the writ, then through the ballot. And the ballot in Hong Kong now is generously to be described as 50% democratic. There is a mood in Hong Kong which is one of growing dissatisfaction among the young, but not only among the young. And I think that this dissatisfaction will not go. It will increase and develop into something even more serious unless both the courts and the legislature can respond to the legitimate calls of the people for what they really expect. The rule of law is a very large part of this, and I watch the situation with some anxiety, but at least when I'm among young people, more hope than anxiety.
Actually, this isn't a bad point to see if there are any contributions from folks out there, because there are quite a lot of Hong Kong young people here today, and of course young people from elsewhere who probably have a perspective on this as well. So I'd like just to ask if there's anyone who would like to contribute to this discussion from the floor, particularly on this question of the rule of law and the democratic condition or partial democratic condition that exists here in Hong Kong. Yeah, Shannon. Microphone there.
Hi. My name is Shannon, and I am a Year 3 law student here. I just have a question that I have always been wondering. In modern times and in the past, we have always referred to the rule of law as some sort of universal value. And while the rule of law is a very contested idea with many different conceptions, I was just wondering, when we're talking about the thick theory, like the thick elements and the thin elements of the rule of law, whether you think there are certain universal values that pertain to the thick elements of the rule of law. To put it in a better way, what I'm trying to ask is whether you think there are certain substantive elements that qualify as a sort of a universal value within the rule of law. I don't know if I'm I'm phrasing my question properly. But going back to how Professor Peerenboom has mentioned that most people would agree certain thin elements are universally applicable. So I'm just wondering if there are certain substantive elements, thick elements, that would be universal to all.
Okay, thank you. Thanks.
Very technical question there. You must be one of Professor C's students who has had to read my book, and so first let's say there's a reason why rule of law is invoked by so many people. It obviously taps into some kind of universal desire for something, and I think everybody. In your most common sense, like people think, look, I don't want people in power abusing their power against me, right? I want to be treated fairly, right? And so there needs to be some constraint on that kind of use of power. And when generally we hear about violations of rule of law, that's the sort of thing we think about most, like people just misusing their power in the legal system to kind of do things that they shouldn't be doing. And particularly government, government and people in office doing it. Although, of course, the private sector could also be abusing their power in various ways, corporations and so on, but you have other ways of protecting yourself against that. In any event, once you move beyond that again, I think that automatically implies you're going to have some sort of system of rules, and the rules need to be applied in certain ways, and that's why you have the general acceptance of the thin rule of law requirement. Beyond that, though, every legal system is embedded within a particular political system, a particular economic system, a particular cultural system, and a particular normative system. And so it's essentially asking the same question that you could ask about anything. Is there any universal agreement about human rights, for example, about political systems, about religions? So you can see that there are many differences on a lot of these issues, and yet people can come to some agreements at some level of generality about, for example, human rights. It's not that people generally, if you give a list of human rights to people, whether civil and political rights or personal integrity rights or economic, social, cultural rights, people don't say, oh, I don't like that, I don't think that's important. They generally like those rights. It's a question of how do you interpret them, and how do you implement them in practice? What happens when they conflict with other goods and desires and so on? And at that level is where you start getting these differences. So I think you can find places around regions and so on where there's more agreement about basic principles, normative principles that define the rule of law. But I think it's you're in the same position as you are with respect to human rights of trying to find what's truly universal when you get into the conceptions of rule of law.
Amy, are you a universalist or are you a relativist?
Well, I read about 3.5 feet of anthropology because my daughter was contemplating reading that for a subject, so I looked into it. I think it's a very good question. It's not an easy question to answer. It wouldn't be a good question if it was, having regard to the importance of the subject that we are discussing. I think there are universal values. After all, it's been pointed out that the average Stone Age individual probably had more personal freedom than the citizen of a liberal democracy today. We sacrifice something of our personal autonomy when we organize ourselves as a society. And until somebody thinks of a better instrument by which to organize ourselves in that way, it is done by law. So the very first thing is that the law is a limit on autonomy and an instrument of power. Fewer people in any society exercise power than have power exercised over them. Therefore, the law has to have some quality which makes its existence acceptable. I find that essentially in my conception of human rights, which without being a natural lawyer, I think you can accept, springs essentially from the human personality, so that it's not for the state to create, but for the state to declare, to recognize, to enforce. What do I think are human rights? Well, I've said that there are certain fundamentals which we can demand for ourselves and must accord to others for the purpose of living and letting live with human dignity. They sound in civil liberties, public participation, respect for otherness, a tolerable standard of living, these and other things. And absent them, you will feel the injustice very heavily upon you. And most people react not to some abstract pursuit for justice, but very often in a reaction to injustice. That's what people start revolutions about. So I do believe that there are universal values, and if they aren't, then what's the law's business interfering with you and me?
All right. I'd like to move things back towards China for the time being and go to that very first question that you suggest you would like to touch on, Professor Peerenboom, which was the major challenges for the rule of law in China today, and see what lessons there might be for the rest of China, because I think we're talking about China mainland, but you may want to talk about Hong Kong as well.
Okay, so to try to build on a little bit of this theoretical edifice we've created here, if you think about the problems in China, they can be categorized in different ways. Some of them are problems that you would find in any developing country. China's legal system really has been recreated since 1978, so we're really looking at only 30 years of constructing a legal system. That requires that you pass a number of laws, requires that you do a lot of training, requires that you have mechanisms, institutions for dealing with legal inconsistencies and all these sorts of things, as well as a whole bunch of other actors, accountants and security regulators and all these sorts of things. So naturally, there's a lot of imperfections in all of these areas, imperfections in the laws, imperfections in the institutions, imperfections in the institutional cultures within these institutions, and so on. So part of the challenge China has is addressing these issues. These are sometimes controversial. They do, people disagree about, for example, some technical reforms which would be better, which should be prioritized, and so on. You can't do everything all at once. But those are not the main challenges for China by any means in terms of rule of law. So really what's happened now is over 30 years, the Chinese legal system has done a fairly good job, the legal reforms have done a fairly good job at creating a basic legal system. A few years ago, the head of the NPC basically said, okay, the first phase of legal construction's over. We have all the basic laws, we have the basic institutions in place. They're not perfect. We'll strengthen them over time, but now the real issue is about trying to implement the laws. But it's also more than just about implementing the laws. It's about the nature of the legal system. Now what's happening is we're getting pushed into actually addressing a lot of these much more controversial issues about what is the purpose of the legal system. Is it to limit the power of the state, or is it to be a vehicle for the state to achieve its goals? What is the balance between social order and individual rights? How should the legal system address those issues? What should the role of the courts be in addressing those issues? Should these issues be handled primarily through a political process, an administrative process, or a legal process? Should these kinds of disputes be pushed into the court system in a very court-centric mode of dispute resolution, aimed at litigation, aimed at sort of adjudication based on formal law, or should they try to be worked out through a very different sort of process? And what is the relationship of the judiciary to the party, for example, to party organs like the political legal committee, or to, for that matter, to the NPC, to the legislative body, or to the executive branch? So right now, all of these issues are heavily contested. You are developing a polity, or developing a much more mature state. And of course, state actors are political actors. They have their own institutional interests, their own self-interest, and they don't cede power readily. They struggle for it, they try to fight. So you've got a lot of very heavily contested political battles going on right now. And so that's the real problem in China, is that invoking the rule of law doesn't really tell you very much about how to solve these kind of disputes. It doesn't say who should handle national security cases and according to what standard, and what should be left to the executive branch, what should be left to the political branch. You could look at what other countries have done, but they actually have wide institutional variation in these things. And in any event, over the last 10 years, as China's ascended, it's become much more confident in the idea that the proper way to establish rule of law is by not just simply blindly following international best practices, but building on China's own conditions and trying to mold its own version of rule of law. So you've got all of that going on. At the same time, you've got much bigger issues, which have to do with the whole economy making this transition from the current development model to a very different, more consumption-oriented model, which is the real focus of the reform effort. So if you looked at the most recent statement, the decision of the third plenum of the 18th Party Congress, it's mainly focused on economic reforms. These are extremely major, comprehensive reforms. They also talk about other areas, including legal reforms, but you don't have that kind of sense of major breakthrough. So you still have this general sense of, we're going to first try to get our economic house in order, and then we're going to continue to deal with these, what I call the more technical, thin issues, and set aside these more contested, politically contested, thick issues until we've sorted out all these economic issues. The debate in China is whether that's a good strategy. Some people think it is a good strategy. Others think that it's going to be very unsuccessful, and you need to engage in political reforms at the same time you engage in these economic reforms. And in fact, there's a real danger that without the political reforms and legal reforms, the economic reforms won't succeed. Any comment on that?
I think that the mainland of China has made very great progress in just about every field that you can think of. In the one that we are talking about, I think that you will be more satisfied with the progress if you look back to see how far the mainland has come. You'll be infinitely less satisfied if you see what a long way it still has to go. And I suspect your dissatisfaction will increase if you see some of the powerful resistance to that progress, not for, I think, anything that, once the surface is scratched, is a respectable reason. Now, of course, the rule of law can only do so much. And anti-democrats in Hong Kong tell us until we become diabolically fed up that democracy is not a panacea, whoever said it was. But how do you improve things by denying it? Now, Dr. Johnson said how small that part of what human hearts endure, kings and laws can cause a cure. Of course, the possibilities of what the law can do is limited. All the more is it unjustified to try and stop the court and the law from doing those limited parts. So the situation in the mainland in many ways is like the situation in Hong Kong. There's on the one hand the law and legal system, and there is on the other hand the political system. We in Hong Kong do not pretend that you can attend to one without attending to the other.
I wonder if I could ask you both to expand a little bit more on this, because there comes a point in which the construction and the rate of progress or otherwise in mainland China begins to have very important implications for the future of Hong Kong, because Hong Kong's constitutional dispensation will run out. It's a time-limited constitution. And it will run out legally in 2047, but it will run out practically a long time before that. Now, the relative progress, if you like, or lack of it, is bound to have a very significant impact on how people view what will happen after the current dispensation. So maybe if you could just talk a little bit more about what the implications for Hong Kong are with regard to China's developing legal system, whichever of you would like.
Well, I think that what happens in the mainland will have an enormous impact on what happens in Hong Kong, and that will become increasingly so as we move towards 2047. But quite honestly, if you are a child of China, or an adopted child like me, and maybe therefore even more devoted to the parent, you will realize that you can't ask this question in any selfish way. What if we were to say to ourselves that Hong Kong will be all right no matter what happened in China? Would that decently make us less interested in what happens in China? I think not. Some people have said that Hong Kong would be an example to the mainland. I think that is too ambitious if one was to exaggerate it. I have never sought to do anything with a view to instructing the motherland. I have simply thought that we would do the right thing for Hong Kong, and if they see that those things, including those liberal things which we hold dear, are not destructive of order, economic progress, or any of these other things, then they might see something in what we do which is of value to them, and they will adapt it as they see fit. If not, they won't. We can't take it upon ourselves to overly attempt to influence what goes on there. We certainly can't attempt to teach them in any way that would savor of the overconfident or the arrogant. We'll do the best we can, and if what we do is of any assistance, then that assistance we are glad to provide for unselfish reasons as well as selfish reasons.
that's a long time period to think ahead, and so many things could happen in China. You could have very different, radically different possibilities, from major economic crisis leading to political collapse and civil war, to a steady progression and a peaceful evolution towards a democratic transition along the lines of Taiwan, perhaps, or some other places, although usually there's some conflict along the way. So at this point, it's really hard to say what's going to happen in China. But I think we can say this, that whatever happens in China, it will have a fairly major impact on Hong Kong, but not in the sense that it's intentional. China is this big, huge place, and what really they would be most happy, the best outcome would simply be not to have to worry about Hong Kong, and not to have to worry about Hong Kong influencing the outcome of the process in China. To the extent that Hong Kong becomes a problem, it's unlikely to end well for Hong Kong in a way that people would like to see it happen. So the ideal scenario would be China manages this economic transition, continues to grow. That has lots of spillover economic benefits for Hong Kong. The development of rule of law is going to be a 20, 30, 40, 50-year endeavor. It's going to take a long time. It's very unlikely you're going to have any rapid political change in the short term, so you're still going to essentially be dealing with a single-party state for a considerable period of time. But within that, as long as it's reasonably stable, that's very good for Hong Kong. Down the road, if things do work out in China, you could potentially see a convergence of the two political legal systems and general economic conditions in the two places, which would obviously reduce some of the tensions. But at this point, it's really hard to predict where China is going right now. In my view, China is at an extremely vulnerable stage of its development, lost a golden opportunity to try to address some of its systemic problems during the last regime, and is now playing catch-up and facing some really severe opposition from vested interests as it is.
Again, I'll just very briefly turn to the audience. Again, those of you who are perhaps young lawyers or just young people from Hong Kong around, do you think Hong Kong has a role to play in helping the rest of China move in the kinds of directions that have been described? I think everyone up here would like to see happen. Do you see Hong Kong as having any role to play in that, or indeed any obligation to contribute to the development of the legal system and respect for the rule of law in China? There's one over there. Gane.
You can just speak loudly.
It's being recorded.
I have a pretty good voice. So I think, at least from what I've seen, and I'm coming to this from the perspective of a U.S. citizen.
Use the mic.
Oh, I see. It's for recording. I'm coming at this from the perspective of a U.S. citizen who has lived in mainland China as well as here in Hong Kong. And I could be wrong on this, but if there is a role for Hong Kong to play, I think that it would have to tread quite carefully. It seems to me that the mainland Chinese authorities do not like being told from outside powers, and I think that Hong Kong would qualify as an outside power, do not like being told what they should or should not be doing, and would see Hong Kong as having been influenced, by the British colonial system for a century and a half, being something different and not understanding the conditions that they would find in mainland China. And so I think if Hong Kong was going to play a role in the coming decades, it would simply be by showing, as I think has been mentioned, showing an example of good governance, showing an example of a strong, robust legal system doing its work, and maintaining stability at the same time that is protecting individual rights, however those might be defined.
Thank you. Thank you. Anyone else like to contribute to this section of the discussion? No? Okay. I'd like now to move to the constitutional relationship between Hong Kong and China. And in particular, the question that was raised before we got into the room by Mr. Justice Bokhary on the effective interpretation and reinterpretation of the Basic Law by the Standing Committee of the National People's Congress on such rule of law as we managed to maintain in Hong Kong, I think was the phrase he used. So, Kim, if you could just introduce this issue.
When in the early 80s, China said it, in other words, they will resume the exercise of sovereignty over Hong Kong, there was great anxiety here. It then became increasingly likely that there would be a treaty and a constitution in which institutions of liberty and liberty itself would be preserved. And then there were questions about, but who will interpret this document? And there was great anxiety about that. People would say, now, who are the judges of the Court of Final Appeal going to be? In all probability, solicitors do a lot of conveyancing for Chinese banks. That's what people used to say. They then appointed judges who were embedded in the previous system, which was meant to be protected. So the powers of interpretation of the laws would be in an independent judiciary. Now, an independent judiciary is a very durable thing. I always take the example of the country from which I have some origins, Pakistan. If the military takes over, as it does from time to time, they suspend the powers of the ordinary courts and set up military tribunals, religious tribunals, and whatever else tribunals they can think of on short notice. No greater tribute to the judiciary could be paid than that. They know that the judges, if left to their own devices, would do the right thing. That's how durable a judiciary is, even if conditions change. The power of interpretation of the basic law is first and foremost vested in the Standing Committee of the National People's Congress, which then, by the basic law, delegates it to the Hong Kong courts in respect of all matters except certain accepted matters. And it is for the courts, before proceeding to final judgment, to seek an interpretation if the matter is an accepted matter. You wouldn't think there would be too many, because no sane man would take out a writ. And if he took out a writ, his writ would be struck out without ceremony, saying that somehow the court should give a decision that this, that, or the other should be done in relation to foreign affairs. But there was one reinterpretation. That was sought by the Hong Kong government. It is an open secret that the mainland sought to persuade the Hong Kong government not to seek it. Seek it, they did. And they got the interpretation which they wanted. There has been one interpretation sought on the initiative of the court, and that by a majority of 3-2, a bare majority, so that for once I wasn't the sole dissentient. And I took it to be a serious matter, because what had, under the previous system, been a question of common law was now treated as a matter of foreign affairs. I could not understand how that could possibly be so, but there it was by 3-2. Now, this power of reinterpretation and interpretation does not affect the independence of the judiciary if you analyze the independence of the judiciary in terms of the court's freedom to decide without being told or pressurized as to what to decide. Subject to one thing, when I said that this did not affect the independence of the judiciary in this particular way, I said it in a conference which has resulted in a book, and an overseas commentator rightly said that what I pointed out had ignored the possibility of the sword of Damocles hanging over the court's head, so that it was under some subconscious pressure to decide in a particular way to avoid a reinterpretation. Now, I didn't raise that matter simply because I had such faith in the judiciary that I didn't think it actually operated. But I think that if you look at it objectively, you have to recognize the possibility. And the independence of the judiciary depends not only on whether the judges are independent, but whether the public is confident that they are independent. And I can't expect every member of the general public to have as much confidence in my colleagues as I myself have. The other respect in which it's going to impact on judicial independence is different. If you define judicial independence more widely, as I think it is customary to define it now, as involving judicial autonomy as well, then the power of interpretation and reinterpretation impacts upon judicial independence. What's the point, some people might say, of saying that the courts will decide independently when it is for them to decide, but from time to time it's not for them to decide at all? They can preserve their respectability, but can they actually perform their function as an independent judiciary? This is a reality which the one country, two systems principle involves, and it's not going to go away. But I think that restraint will turn the situation into one which is acceptable. An absence of restraint will lead where I do not dare to predict.
So, when I listen to this, it sounds very complicated and very technical, and I think we just need to step back and think about this, not in terms of Hong Kong and mainland China, but just as a political scientist. And just think of a country or an organization that has 1.4 billion people, and it's got a subpart that has 8 million people. Somehow that organization has to control the whole organization. And it's going to set policies in a way that essentially operate to the benefit of the 1.4 billion people. The 8 million sub-department cannot sort of override the whole organization itself. So that's the reality here. Somehow China has to, mainland China has to somehow have a way of making sure that the 8 million tail does not weigh the 1.4 billion dog. So there need to be mechanisms in place to do that. The Basic Law provides a framework, and you can specify certain issues, of course, ex ante, that should be left to this party or that party to decide. But as everybody knows, conditions change. So there has to be a more dynamic mechanism, principles of interpretation that allow the power, the top power, to decide what ultimately is going to be a threat to the larger entity. That can come in the form of challenges through the judiciary. It can come in the form through the more recent debates about universal suffrage. It can come in more specific aspects of, for example, the debates over Article 23 and what can be done and not done in mainland China. But there always has to be some mechanism where Beijing is ultimately going to be able to say, now, we believe that at this point, national security is being threatened in some way. The overall entity of China, its interests are being affected here. Now, if just as a matter of practicality, they're not going to want to do that all the time because it's very difficult to do. It upsets people in Hong Kong, raises all these issues about legitimacy and so on. So there are a lot of practical reasons they don't want to go down that road. So so they're not going to be doing it sort of willy-nilly or all the time. So one approach to how to handle these issues would be to try to say, let's first try to build up the informal conventions and mechanisms for handling these sorts of things, try to establish trust about how these things are going to be handled, and then, over time, you'll be less worried that we're going to kind of wander off the reservation. You'll therefore give us more autonomy to actually decide things. That's a path you could take. That actually hasn't been the path that Hong Kong has taken, whether on the democracy side, which continues to challenge and push the envelope in ways that Beijing doesn't find acceptable, or, for that matter, if I may say so, the Court of Final Appeals chose in the right of abode case, which was a very aggressive decision very early on, coming out of the blocks, that essentially declared a robust power of interpretation for the courts here. And that, I think, predictably enough, led to a rebuke from the NPC that tried to restate the power relationship in no uncertain terms, and may have actually then limited or restricted the court's maneuverability going forward in ways that could have been avoided had the court taken a more less aggressive approach, tried to work out mechanisms for dealing with this, or a more deferential approach, however you want to refer to it. So we were talking earlier about this. It's like if you have, I don't know if any of you have teenage children, but if you have kids, you always would like to give them as much autonomy as possible and let them decide. But you always give it to the ones who are the best students and most responsible and don't really need it, right? But if you have the ones that are pushing and challenging your authority at every stage, you tend not to give them as much space. You rule them with a heavier hand. So in that sense, it's in making demands to Beijing, you can understand why you want to do that, stake out your biggest scope of territory and defend your turf. But it also sort of goes into a bit of the assumptions of it. So when you come at these from a liberal democratic angle, you generally think that you start with autonomy and the notion of autonomy, and then the state can maybe limit that. But in China, you very much start with a different assumption where the state controls the public space and you kind of earn your spheres of autonomy and are ceded spheres of autonomy over time based on your performance and your perceived threat value to the regime. So I think the relationship constitutionally between Hong Kong and China will fluctuate over time, but will ultimately be one in which, when Hong Kong is least threatening, it will have the most autonomy. And perhaps when it needs it the least, then it will have the most autonomy. So there's that kind of dynamic that basically underlies a one country, two system situation.
Hong Kong is a disruptive teenager.
Well, I assume that you don't mean that.
What part? No, that
Well,
the
all of
analogy
it.
doesn't fit it in all senses, of course, but you get
Right.
the general point.
Well, I tell you this, that what you have said sounds a lot like what has been said to me in public by mainland officials. It has no bearing on what they say to me in private. We are not here to stake out this or stake out that. China did not have to treat Hong Kong as a separate special administrative region. Didn't have to wait until 1997 to resume the exercise of sovereignty. This was a choice which was made by the country, and we take the choice because we respect the country as a sincere one, which they mean. We have never asked for anything other than that which, on any sensible reading of the basic law, is conferred upon us. Now, if by being more deferential we could get more, then people can decide whether they wish to be deferential in order to get more. But just think about how much you would lose by being deferential. And I don't believe for 1 minute that we could achieve anything other than the way that we do it. I don't know if the National People's Congress rebuked the court. If they think they did, that is fine. What is the important thing is that we did not rebuke ourselves by failing in our duty. We took the one country, two systems principle seriously. We respected it. We're doing it for the people of Hong Kong. I could have afforded to retire by the time I went on the High Court bench at the age of 41. I was asked by many people what I would do when 1997 came. Would I leave? And I always said, no, I will stick it out with you. I can't promise you anything except this, that as far as the behavior of the judges are concerned, what you see on the surface will represent the reality. That's all we can do. And I don't think we can play politics. We're not good at it. We will do what it is right for judiciary to do. People of Hong Kong expect it. We will do it. That's all.
Okay. I think we've reached the point at where my timetable, we're running out of time, at least the timetable I was given. There is just one last question here, which it was one of the questions I think that Professor Peerenboom wanted to explore, and then I think if we can take that and maybe wrap up, if that's okay with everyone, which is, and the question, again, is back to a fairly general question about the rule of law, and it was what does China struggle to establish the rule of law? Tell us about law and development and the rule of law more generally. And I think that is an important question because until I came here, of course, after teaching law for 40 years, I hardly ever talked about the rule of law. It simply wasn't anything we talked about back home. Yeah, it just didn't matter. Although I have to say, in the last 10 years, the rule of law has actually become a live topic of conversation in the UK as well, and that's paradoxically because of the steps that were taken by Parliament to embed in the British legal system the European Convention on Human Rights, which I would have thought was, most people would regard as a pretty serious reaffirmation of a commitment to the rule of law. Paradoxically, what it's done is it's created significant tensions within all branches of government and serious challenges to issues of judicial independence by politicians who, in my view, really ought to know better. So I think, are there things that we can learn from other people's struggles to establish and maintain the rule of law?
So this is where I think when you look at China, you need to look at it in a comparative perspective, and you need to look at it in terms of many different factors that affect the development process. So political scientists tend to look at it in terms of authoritarian regime versus democratic regimes. And there's a whole new literature on the role of law in authoritarian regimes, which is generally more robust than people give it credit for, because there's all sorts of practical reasons why authoritarian regimes want to pursue legal reforms, but also the limits of it within authoritarian regimes. At the same time, there are, of course, many problems with rule of law in developing democracies. So the other thing that I think China really shows, and that we can learn a lot about China more generally, is the role of different stages of development. So much of my recent work has been looking at China and looking at middle-income countries more generally. So the reason why people don't talk about rule of law that much in high-income countries is because it functions well in terms of this thin rule of law. And if you're talking about competing thick conceptions of rule of law, either there is general agreement about liberal democratic rule of law, or everybody realizes what you're really talking about are politically contested concepts for which you might as well just have the debate straight out rather than couching it in terms of rule of law. Whereas in middle-income countries, you're dealing with all of these sorts of issues that I talked about earlier, about the relationship, these very basic constitutional issues about the relationship of the judiciary to other state organs and the respective powers and responsibilities that they're trying to work out. The problems that they have with economic and social culture rights and the different ways of handling them. And that has a lot of implications for the notion of judicial independence and the role of the courts and so on. So I think there's a lot that we can learn from China about legal development, law and development, rule of law promotion more generally. But conversely, where to really understand China's issues, you need to bring in these multiple comparative perspectives and then sort out in any given issue what's a development issue, what's a political regime issue, what's a path dependency, cultural legacy effect, or in which case, in some cases, there'll be multiple effects. So only in that sense are you really able to kind of get a firm handle on what's happening in China and where things are likely to go. So I think we can learn a lot about it. Of course, China also has its very unique features, being a very large country and so on. But I always encourage everybody to approach these things from a much more comparative perspective and much more interdisciplinary perspective. I think that's what we should take away from the discussion of China.
Well, my experience, Chris, was exactly the same as yours. It was only recently that the rule of law loomed large in my thinking. I think there was a time when students were interested in the rule of law only to the extent that it might feature in an exam question, and quite understandably so. And of course, it is where liberties are under threat that people's minds are most focused on liberties. That's absolutely right. I think that if you compare Hong Kong with developed countries, Hong Kong's unique situation, a special administrative region, maybe secure, maybe precarious, the danger of an utter overthrow of the rule of law and a complete destruction of freedoms is, of course, a much graver danger in Hong Kong than in any developed democracy. But the danger of erosion through neglect or lack of interest on the part of the people is less here than it is in a developed democracy, because we are that interested in it. So yes, life would be simpler if we didn't have to worry about these things. I often say, thinking back about the days when I practiced commercial law, that it was a wonderful time when all the clients were old and ugly enough to look after themselves, rich enough to pay our fees, and we had nothing to worry about as far as rights were concerned, except our rights to charge like a wounded buffalo when it came to our fees. The times have changed, and we have changed with it.
Very good. I'll invite folks in the audience just to see if there is any final contribution from the audience. Wow. Around this question of what we can learn from each other in terms of the rule of law. But if there, yes, one in the middle.
So, Professor Peerenboom, you said that China is entitled to have a right of reinterpretation to make sure that Hong Kong is in line with the national policies and so on. And you said that this will not endanger the rule of law because China wouldn't want to abuse this power because clearly it would be contrary to public opinion. But wouldn't you think that if that is the only line of defense we have against a case of executive power overreach, don't you think that that is a horribly fragile line of defense against that? And shouldn't it be and of course, having this power of reinterpretation opens the danger of the executive bypassing the judiciary to reinterpret decisions that it does not like in order to facilitate or enlarge political executive power. So it seems to me that the one who should seek reinterpretation should be the court instead of the government or the executive.
Short answer to your question, yes, it's a terrible position to be in. But that is life in a one country, two systems situation. That is simply the nature of, and it's the NPC. China could revoke the treaties, could do all sorts of things, and make it much worse. Cancel the basic law, basically do something much, much worse if it really felt the need to do it. What would the protections be? What would Hong Kong be able to do in that scenario? Really nothing. They could appeal to the international opinion and so on, but if it really became the point where China wanted to send in the military because they thought Hong Kong was totally out of hand, destabilizing things and so on, presumably they would do that. The question is, why would that ever come to that? How could it ever come to that? Why would Hong Kong ever rise to that level of threat to the mainland, right? And certainly that is a very far extreme kind of hypothetical that's being thrown out there. So it's really more about managing expectations of both sides and trying to find solutions, the old proverbial win-win solutions, right, where you get as much as you can by way of following your goals, maintaining your system, having as much autonomy, both political and judicial, and at the same time, mainland China feels that the regime feels it's not being threatened by this, and in fact they're benefiting from this arrangement. So to me, it's not a comfortable position to be in, for sure. It's never a comfortable position to be in when you have the weaker hand in any situation, legally, politically, or just realistically. But the question is, given that you have the weaker hand, how do you play it?
Well, I don't have very much to add to that. I think I know what you're thinking. I agree with you.
Very well. I think probably that's a good point at which to draw things to an end.
Thank you very much for the discussion. Would Professor Peerenboom, Mr. Justice Bokhary, and Professor Gane stay on stage? Sir James Marlies will now present a souvenir on behalf of Morningside College. Thank you. Professor Peerenboom, please. Please stay for a group photo. Group photo. Thank you, Professor Merlis, Mr. Justice Bokhary, Professor Peerenboom, and Professor Gane. The dialogue has come to an end. Thank you for joining us tonight. And on behalf of Morningside College, I would once again like to thank Mr. Justice Bokhary, Professor Peerenboom, and Professor Gane for speaking today. Thank you and good night.